All right, welcome back to the afternoon session. The third session of today is presented by Professor Deng Feng from the Peking University, and followed by a comment by Professor Andrew Lin of National Taiwan University. And let me briefly introduce Professor Deng Feng. He's from Peking University, and he received his PhD in law from Renmin University in China, and also he did a postdoctoral with studying industrial organization theory, and he has published many articles and books. And today's topic is on isolated stakeholder model, and which is relating to the state-owned entities. So the floor is yours.
Yeah, thank you, Professor Iida. Thank you. It's very nice and honor to exchange my viewpoint about the recent development of Chinese SOEs legal institutions. I have a slider. I'll start from. My paper is composed of four parts. The first is describe the Chinese SOE system from 1993, adopted from Singapore model. We called the SOA legal system, state-owned asset management system. But after the corporatization, actually it's kind of turned the state-run SOE to the Singapore model, which means use the normal or common corporate law to regulate the whole SOE. It met a serious problem in stakeholder perspective. Actually, I think after 1993, the Chinese SOE system are kind of get improved in efficiency at the cost of the other stakeholders. So the second part described those conflict of stakeholders that is Chinese aligned model of Singapore model of SOE. But the recent years, especially from 2015, there is a big switch in Chinese SOE legal system, which I called is from SOA system, which state-owned asset management system, and back to the SOE system. So that's make a very big switch by the CSEC, the ultimate boss of SOEs. That is an enhanced conflict with other stakeholders in corporate governance. At the last parts in my paper, I described the Chinese current system of SOE system is kind of a unique model in the whole world. So it's that's the sketch structure of my paper. I'm sorry, it's very roughly draft paper, so I didn't finish yet due to the time limits. But what I'm emphasized is to lets the, people know there is a big switch in recent development of Chinese SOE legal system. So that's the core idea of my presentation. So I start from this chart. It's easy to grasp the essence of the Chinese SOE legal system design. From 1993, the Chinese SOE step by step turned into a leaned Singapore model. Actually, I think in 1984, the Prime Minister of Singapore, Li Guangyao, visited China and met Deng Xiaoping, and he introduced to Deng Xiaoping that Singapore is a quite good model of SOE. So in 1988, several officers, include many later influential scholars like Zhang Chenlin, Professor Zhang Chenlin, who worked in World Bank, then, and Zhou Xiaochuan, and Professor Wu Jinglian. So they visited Singapore, and then they developed a theory of how to reform the SOE system. So from 1993, so the step by step, the China has established the system copied from Singapore to like this. So you can, from the top level is the government should be acted as SOE shareholder, and there is a mixed ownership system. So in any specific SOE corporations, there are some public shareholders and private shareholders, which means some are SOE shareholders. The ultimate of the SOE shareholder is CSEC. And so this is part of the law called state-owned asset management legal system. But there is a very clear distinction. In 2008, there is a law's very clear expression. The government and the corporation should be clear, distincted. Should be clear, distincted. So in the second level, in any specific corporation, you can see on the map. So in a specific corporation, the ultimate power agency is a shareholder meeting. So the SOE shareholders and non-SOE shareholders can act like a real shareholder. So they vote according to their share or other mechanism like their investment contracts. So the shareholder meeting then select a board of directors, which is quite popular in the whole world. So the board of directors then select the CEO or general manager to run the corporation. So in any specific corporation, whether you are a SOE shareholder or non-SOE shareholder is distinct from the corporation. The corporation need to follow the civil code. Right now, we follow the civil code and the company law. So it's deemed as a civil legal subject. In the first level, is a domain of, we call it the SOE law, which promulgated in 2008. But the second level is you must follow the company law, which the first draft of the current company law is 1993. Then there is a big revision at 2005. In 2023, there is a second big revision of the corporate law. So that's the basic structure of Chinese SOEs legal system. So actually, before 2015, there are no such kind of legal definition about what is SOE. So it's only, in people's mind, because this corporation is controlled by the government ultimately. So we can call it SOE, but it's not a legal definition. All corporations are same. All companies follow the company law. So that's the core idea of the Singapore model and the Chinese copycats. But in 2015, there is a big switch. First, after 3 years of President Xi's first term, so he wants to improve the SOE system. So in 2015, the president, under the President Xi's instruction, so there are 3 very important documents was issued by both the Central Committee of CPC and the State Council. The core idea of 2015 is managing the equity, not assets. So that's the idea proposed by the Ministry of Finance. That is kind of more close to Singapore model. But there is a big policy switch in 2015, so everybody guess why. Because sometimes we call it's a huge back off from the original intention of the reform. So in 2000, it's after 1 year, only after 1 year. So as CSEC published this very important internal measures for regulating the SOE enterprise. It's called the Measures for the Supervision and Management of the Trading of State-Owned Assets of Enterprise. That's a very, very aggressive legislation. It's kind of an administrative legislation, but it's also, in my viewpoint, it's kind of violating the constitution behavior. But no one in China can, say no to the CSEC's internal command. So that's the problem. In 2016, the measures, so the CSEC established a new standard for how to identify a company as a state-owned enterprise. So it's divided in 4 kinds of SOE corporation or enterprise. The first is called the wholly state-owned enterprise. The second is called the state-controlled enterprise, which means the aggregate shareholder ultimate control by the state exceed 15%. So if there is the third concept is in my paper we use the name the effectively controlled state-controlled enterprise. Maybe we can describe that as de facto controlled state enterprise, which means the aggregated share by all the government bodies, all the government enterprise less than 15%, but through the contract or through other mechanism like voting trust, you can be deemed as controlled by the Chinese government. So it's called. So that's a very, very serious and arguable concept. So the fourth is it's not controlled by the state, but the state has some kind of invested interest in there, in the company. So I use the words called companies in which the state hold a non-controlling equity interest. So it's called. From 2016, so all the things are different. Before that, all corporation companies just follow the company law, I mean in corporate governance. But after that, so the first thing we needed to identify this corporation whether it's also SOE. Any kind of those four categories, so it must be identified first. Then there is regulatory duties for those SOE corporations, which means if you want to increase capital, then you want to transfer your shares and substantive assets transaction, you need to be approved by the CSEC or your ultimate controlling shareholder, which normally follow the bureaucratic way. So that's the very important switch in Chinese SOE legal system. But for CSEC, it's very for CSEC, this measure is only considered as administrative legislation, and also it's only effected through the command system by the government internally. So there is a big loop in this measure, which caused a serious problem in China currently, which call there is a illogical loop, which means that even for those companies, the government share exceeded 50%, there is a possibility, it's very likely happened. Actually, it's quite popular in China. So there is a common control between the public, between the SOE shareholders and the non-SOE shareholders through shareholders' agreements. So that's called a controlling block without a unique controlling power. So if you are a private investor in SOE corporations, your share is only like 13%, but there is an agreement between you and the government. Actually, you have the control power, but the government will violate the contract with you because of the major identify your corporation as a state-controlled corporation, so which cause a lot of conflict and suit currently happen in Chinese courts. So that's a very impressive phenomenon in Chinese current situation. So that's the core issue of what I'm talking about. So that's but the interesting thing is there is a war, a silent war between the scholars and different Chinese government branches and different intellectuals. So although after 2016 there is a big switch, just like I just described, there is another backlash from the legal circles, especially in 2023, in the new version of company law, the company law still use the state invested enterprise. It's a very narrowed concept compared to the 2016 measures. So in just like Article 168, it's called the term state-funded company. In this law, refer to wholly state-owned enterprise and a state-controlled enterprise, including state-funded limited liability companies and joint stock companies. So that concept is still keep the 2005 and the 2008 SOA laws concept way. So it didn't change. So there is a big conflict between the People's Congress and CSEC. Then, right now, this is a conflict between the CSEC and the other Chinese SOE related laws. 2016, the company laws new version, and 2020, there is a very big, important regulation in China. It's called the Optimized Business Environment Regulations. And 2024, the State Council passed the Fair Competition Review Regulations. So that's the one way. It's a liberal way. It's still want to go back to Singapore model. But for, the SOA system. But in the right, the 2016, the CSEC, the internal measures and policies is different. But this time, the CSEC has started a new drafting process for revision of SOA law. The 2008 promulgated SOA law. So the CSEC wants to snakily insert its own internal measure and policies into the SOA law. So that's a problem. So at last, I want to, that's a very brief introduction about what happens in Chinese SOE legal system in the last several years. So Considering our topic is stakeholder model of corporate governance, so I think SOE is typically there is a common understanding about SOE should be take the corporate governance model as a stakeholder model. But after 1993, after adopting the Singapore model, so Chinese corporate governance has a huge suppressed stakeholder interest. But from 2016, the situation is getting worse. So currently, for SOE corporation in the whole world, China becomes Chinese model becomes a unique one. For most countries, there are many SOE corporations. In generally, it's maybe in legal definition, it's called the public corporations, which means you provide the public utilities, public service for the people in a fair and a controlled price system mechanism. But that's all the companies' stakeholder model. There is a special one like Singapore, which the law treats the SOE corporations as a common corporation, which means it's no difference with other private invested corporation in the law. But when government gains the dividends from the corporation, then it's make a fair distribution to the whole people. So it's a combination of private laws corporate governance with public stakeholder value, stakeholders' value or interest model. But China is a different one. You can say from the last 3 decades, so there is an ongoing growth to ignore the other stakeholders' interest. So, but after the SOE corporate groups getting bigger and bigger, efficiency way is accumulate a huge revenue, but there is no any distribution to the whole people. So I think it's kind of, in 17th centuries, Tudors in British history, it's Tudors model, which means the SOE system become the king's property, not the whole people's property. So that's all I want to say. That's the problem. So I should stop here. It's already half an hour. I hope I have more time to exchange my viewpoint with you. So that's all. Thank you for your listening.
Thank you so much for a very insightful presentation on the Chinese SOEs, and you gave me a very good and helpful framework to all such kinds of SOA and SOEs, and we learned a lot already. So, so the comment from Andrew.
Okay, good afternoon. I think we need some coffee, to wake up. Okay, so this is, 2025 Asian Corporate Law Forum, but when I made this latte art, I think I was asleep, so I put 2005, and then I make some modification. Maybe in 2005 already, think of the creation of ACLF. Okay, for me, I'm sharing what I have learned from Professor Deng's article. I would actually recommend all of you to read, in more carefully, spend more time. 30 minutes is not enough to get to know. Even as a neighbor, I don't really know what happened, in the fence of my neighbor. So, so stakeholder interest of the SOE is the main theme of this article. And Professor Deng actually come up with a conclusion that from his observation, China's SOE is kind of unique, isolated stakeholderism. Okay, so I put stakeholder interest, whether this is the stakeholder interest is being isolated or is only conceptually exist in the SOE. Okay, first of all, I think this is a very fascinating paper. Professor Deng is a distinguished corporate law professor in China. Okay, so he's in a very good position in writing this article. Okay, so this article, provides readers opportunity to quickly understand the SOE and SOE corporate governance regime in China. Okay, but I do have a kind of, after reading, I'm thinking whether Professor Deng can provide any solid suggestion with regard to the SOE reform, in addition to your observation of the evolution of SOE corporate governance. Okay, so Professor Deng already mentioned about the fundamental changes from the three different company law revisions, 1993, 2005, and 2023, and also in the process, in addition to the company law evolution, we also see SASAC as a policymaker regarding the SOE, also actually have promulgated many different kind of guidelines regarding this. Okay, and as mentioned by Professor Deng, there's actually a conflict between the company law approach and the SASAC policies. Okay, so here, fundamental changes is enhanced, whether this is going to enhance the party leadership, okay, and whether this mandatory revision to the corporate charters and state advancement and private sector retreat, which you can also see this at the end of the article, says, state advancement and private sector retreat model is one of the observations from Professor Deng, and of course this is controversial, and whether this is optimal for China or not is remain to be discussed. Okay, so here another fundamental change is from SOA, state-owned assets management, to state-owned enterprise management. But even so, I'm considering both are the same for me because it's all under control of the state. Just in different form, because assets may move to the ownership become held by SOE. Okay. Okay. So for SOE reform, from the paper, I'm thinking of one thing is whether SOE reform is equivalent to corporate governance reform of SOE. And also in this article, it's talking about SOE, semi-SOE, and non-SOE. But even for non-SOE, maybe it's still SOE related because it's SOE invested, which does not have a, maybe not controlling shareholder. But I do have a question regarding controlling shareholders. One is past 50%, one is less than 50%, but you are still actually controlling. So I will talk about this later regarding corporatization and privatization. These are two things. Okay. Okay, so one thing is the separation of the function. So the government as a public administrator and the SOE as an owner. So the government's role considered need to be separate. But even so, whether this separation is an illusion, as you mentioned in the paper. So I think this is a good question to be considered. Okay, so and we see from the reform there are also restrictions regarding the appointment of directors, officer, and certain types of transactions of the SOE is governed by law and policies. Okay, so then the second one is talking about the bottom is the corporatization of SOE. Professor Deng says this, in the process of corporatization of SOE, is packaging the SOA in the guise of private enterprise. Okay, so it turns out to be the SOE, unlike SOE and unlike ordinary company. So what is it? You want SOE to become an ordinary company to have efficient management and so on, like the ordinary company in corporate governance. But in the meantime, the state remain control of the SOEs. Okay, so one critical issue is what is in the mind of the China's policymakers, whether privatization of SOE is truly in the mind, is the policy. Okay, so this is one thing. Do you really want to privatize? When you really want to privatize, it means that you want the public investors to share the growth of the enterprise. And of course, you need to, SOE has, company in the form of companies and non-companies. And of course, if you want to have the public to share, you need to corporatize to become, share companies. At least this will be the first stage. Okay, so effective operation, business ethics, corporate governance, and internal control sustainability will be, for regular corporation, including the SOE, also need to, seek for. Okay, so I think for this policy, whether this is truly the policy, because this will also affect the policy and attitude of the state in pursuing and enhance a balanced and optimal corporate governance for SOE, for both the state-run enterprise and SOE on the road towards privatization. Okay, and another question will be whether corporatization of SOE will change the way they are managed, and also they change the corporate governance models of SOE. So as Professor Deng mentioned, there are many different kind of opinions, even among scholars and different government branches. They do have different kind of opinion regarding toward the answer. Okay, so corporatization for me is not equivalent to privatization, but this is a pre-stage. And then whether you really want to privatize. Okay, and the next one is talking about definition and types of SOE. So in reading Professor Deng's article, I really suggest that you can define your discussion at the very beginning. What do you mean by stakeholders? Does stakeholder include in shareholders? So even shareholders, we have controlling shareholder, we have different type of stakeholders. Whether the state itself, as mentioned by Deng yesterday, whether state itself 2 days ago is also a stakeholder. Okay, so state's role in different types of SOEs, are there any distinctions? To me, it's still not clear, because I cannot get a picture of how many SOEs are in China, and different type of SOEs. Just now you mentioned there are at least three types of SOE, and another one is that the government control less than 50%, still invested but still have influence. And another question is whether SOE are listed company. If they can also be listed, what type of SOE? If the state owns more than 80%, would this kind of SOE be listed? So if it is listed, whether the corporate governance of this type of SOE should be different from others. So these are all questions in my mind, and I'm hoping that Professor later on can have more description in his article. Okay. So the other one is for the publicly held corporation or the SOE, whether a two-tier shareholding system exists in China, which means for one for promoters, you mentioned your article, one for promoters and the other for retail investors. Okay, so whether this is truly two-tier or is the SOE, the state maintain the control of the majority shares. Okay, so I just mentioned stakeholders definition. That would clarify, after you clarify the definition of stakeholders, the reader will be easier to understand what you mean by isolated stakeholder.
Okay. Could you conclude in a minute?
3 minutes. Okay. So some I will just go very quickly. So one is the SOE reform, corporate governance reform of SOE. So I draw there are so many stakeholders in this picture. So you can identify. So what do you mean by stakeholders? Okay. So I'll skip this, and there are a lot of questions. I may not need to repeat. These are going into the detail of the articles of Professor Deng. So whether state is also a stakeholder, and then whether you consider the isolated shareholder model is a good corporate governance model, or deterring the promotion of good corporate governance of the SOE, would it be improved by another corporate law reform? Okay. So then the next one is the corporatization, privatization I just mentioned. Professor Deng mentioned about the whole people interest. So from the SOE, whole people as the stakeholder. So whether the ESG, ES, human rights, labor rights, poverty, and so on are also included in whole people as a stakeholder interest. Okay, so if the answer is positive, is it appropriate to say that stakeholder is isolated? People interests are always on the top. But they just cannot or need not be exercised because the government will exercise this right for them. Okay. So what would be the optimal SOE model for corporate governance model? So whether this one or this one or this one. Or this one. Or invisible, isolated. Okay. So I mentioned about playing golf. So how do you distribute your weight on your foot? Okay, so stakeholders and shareholders, and so many different type of stakeholders, how you distribute your weight here. So whether in SOE, shareholders' interest is still the center. Okay, so OECD has some rules regarding SOEs. I would suggest that you probably may also put in your paper regarding the most recent rule and guidelines promulgated by SOE. Taiwan also has SOEs, but we don't really pay attention to that because we have only 17 SOEs, nationally SOE, and it is monitored by the Congress, and also is regulated by company law and also the other relevant law. And privatization is the policy of Taiwan. Okay, so conclusion, political culture and mindset of the leaders of the reform determines the result. Corporatization, privatization of certain part of SOA and SOE and corporate governance of the SOE will be important to consider. So policy change and whether it is truly bringing into implementation. One is policy change, one is law change, one is implementation. Okay, so motivation and values, investor protection, investor education, education of SOE managers and policymakers, and change in thinking, in thinking of policymakers and SOE managers are also important to have the reform successful. So this is a great and fascinating paper by Professor Deng. And so corporate governance of SOE in China are different and unique, so different from other countries. So what is the optimal models for China? There are so many different kind of models mentioned in Professor Deng's paper. Okay, so and then a suggestion would be Professor Deng can in this article or write another article with some comparative studies. So, and my wish is that Professor Deng can influence and lead the SOE corporate governance reform in China. Okay, so it will become a better stakeholder of this picture. And thank you for your listening.
So thank you very much. So there are so many questions to answer, but due to the time constraint, let me begin by correcting the questions or comments from the floor, and then after, please answer or respond to the some of the comments or questions. So is there anyone? So Dan.
So yeah, I will try to keep this short, but Professor Deng, I think it's a wonderful contribution, yeah, and the reason why is I think that in the comparative literature, people haven't paid attention enough to this 2015 shift, yeah. So just on that point, I think it is terrific. In terms of your characterization of the Singapore model, which I've written about with a number of colleagues at NUS, I think it's absolutely right to call the Singapore model a mixed sort of stakeholder model that works like a corporation at the ground level, but then when the dividends are paid back to the government. So I think you got that perfectly right. In a piece I had, No Need for Asia to be Woke, it's exactly how I had described it. But one thing I would suggest with the history of the Singapore model at least, myself and Tan Cheng Han and Umakan Veritil have a piece, and ironically it was published in 2015, so just before this change. And we suggest that even Singapore, although China correctly, I think, modeled after Singapore, there's no doubt about that. But Singapore went one step further, right? Rather than just creating a holding company of Temasek, there's a number of laws which limit the government's right as a controlling shareholder greater than a regular controlling shareholder to ensure more separation from politics and the ground level board. And I can send you two papers on this, and I don't think China ever sort of reached that point. And the only question I have for you is, you know, what is the effect of this 2016 change in terms of government influence? Because I think that is the key for the Singapore model. Singapore has always been working to be the shareholder, but to let corporate law, as you properly describe it, regulate and to keep politics out of the boardroom. I suggest what you're saying is after 2016, that eroded in China and now it's trying to pick up. If that's the story you're telling, it's fascinating. But we can talk after. I have much more, but yeah.
Professor Kim.
So how do you appoint, I mean, how the CEO is appointed now in Chinese SOEs? I mean, has there been any change after 2016?
Thank you. And no more. So please respond to several questions or comments as possible, as short if you can.
Thanks, all of you. It's a wonderful question. I think I start from the last one. It's easiest to answer. So the CEO appointment is currently is changed by the 2016 in this way. The first, before that, the CEO is selected by the SOE corporation's majority shareholder, or the biggest shareholder. But after 2016, if the specific corporation's majority shareholder is SOE shareholder, it's the SOE of the specific corporation is appointed by through the peer-through regulation, must appointed by the ultimate. I mean, if there is a corporate groups, there are different levels of corporation. So this SOE must right now appointed by the top level, which normally is the government itself. So it's a bureaucratic way to appoint SEO right now. So that's a big switch. That's a big shift from the old time. Yes, I think Deng's observation, I'm quite agree with you. That's important. I didn't know that, the Singapore has so, advanced ideology to promote the independence and autonomy of the corporate governance. So I totally agree with you. That's a good, I think a good development in Singapore to regulate the government power, to make the separation of the government and the corporation is much more, cleared. So that's good. But China is different. It's on the contrary, it's totally different way. So through the 2016, it's enhanced the government intervention for the corporation business decision. So I think that is a very important understanding for why the mainland China adopt the Singapore model. We want to separate the government decision from the business decision. So whether you take a stakeholder corporate governance or you take a stockholder governance, it's a corporate loss problem, not a government's problem, not an SOE's problem. So so one of my teacher, very influenced economist in China, he described the Chinese SOE reform like we want to paint the white strip, a black strip on a white house to make the house into a zebra. So that's the reflection about your question. So the hardest is Andrew's lots of questions. So I think first I want to emphasize so what I'm talking isolated model means it's isolated SOE model. So not in a corporate governance way. So that's the first thing. So what is a stakeholder? That's dependent on our definition. So I think in Asia countries there is a very strong tradition. We think the corporation or companies as a vehicle for entrepreneurship. So the silent shareholders or inactive shareholders, I think they all actually like credit situation. So because you didn't take part in the decision making. So that's what I'm using the concept of stakeholder. So that's in corporate governance way. Yeah, I think you bring out several very genius insights. First, the listed cooperation problems. So that's the very clever observation in China. The CSAC, I mean the SAC, the CSAC didn't invent. The CSAC is ultimate boss of the SOE, but the CSAC has no boss to intervene the listed corporation, because the listed corporation's corporate governance is governed by Chinese SEC. So if there is another powerful agency, government agency, regulated the corporation, so the CSAC will step back. So not only listed corporation, but also insurance company, banks. The banks now become a listed corporation in China. So the CSAC cannot, intervene its decision making of the SEC, CEO or high officers appointment. So that's a very interesting thing. So in considering you ask me what I'm suggesting, in 2015, I published a very popular article. It's like a newspaper's review. It's called Abolishing the CSAC. Abolish the CSAC. Several years ago, when Vietnam, took the same, abolish the CSAC right now. So that's the one way to, make the Chinese model more like Singapore model. Even in actually, it's also the same way to understand the Chinese situation. In 1993, the beginning of the Singapore model, we only use the company law to regulate the SOE's corporate governance. So that's enough. So the company law is a good model of balance different stakeholders, whether, we have a lot of technical arguments, but the company law is enough. But in 1994, there are some leftists in China using Marxism philosophy. So emphasize there is a tendency to, the loss of state-owned enterprise, state-owned property. So that's a dominant, political slogan in China. So, besides the company law, they aid up more and more regulations to make constraint on those, three majors and one big. So if you want to increase capital, if you want to transfer the share, if you want to make a substantive asset deal, so you need got CSEC's approval. So that's the problem. So you don't trust company law. So you use SOA laws to enhance the regulation because you think this is a different corporation. This is a different. Your intervention is based on the ideology. You think this is a public corporation, not a mixed shape or not equal or the common corporation or companies. So that's the problem. Yes, I totally agree with you. It's a kind of, in China, it's determined by the mind of policymakers. So that's very important. Yeah, the current shift is because of President Xi's mind, because he more worried about the loss of state-owned property. So this will treat. I think several years ago I published a Chinese article talk about this. So the government do not own anything because it belongs to the whole people. And so that's our Confucius philosophy. If you want to get respect from the people, you should not own anything. That's what my conclusion. So it's become more and more the king's property, not a socialist country, a socialism country, as whole people's country, a country based on the social convention, something like that. It's not a modern state philosophy. Yes, that's right. I totally agree with you. So, but for corporatization, I don't think it's equal to privatization. So that's the essence of the Singapore model. That's my opinion. So yes, I hope I can play a bigger role in current legislation of SOA law. So I think I'm already the top enemy of the CSEC. We have an association called SOA Management Legal Association with a lot of scholars and lawyers. We want to, like 2016's company law, we want to block the CSEC's, misconduct. So, the SOE is the Chinese, the main and the core character of our economic system. So it's hard to answer all of your questions. I hope I can I have some kind of, response for what you proposed question. Thank you.
Thank you so much. So let's conclude with a big applause with them.